Thank you. Thank you so much for having me. I appreciate everyone being online. As you know, we have some contract changes. Yes, we do. These are going to be mandatory as of June 1. So I just wanted to go over them. I do have copies of the red line. So this is actual copies of the proposed changes, and you will see what's different in the new contracts versus the old contracts. So what I'd like to do is go over each form. If you have questions, I would love to take your questions at the end of the form, and then we'll just move along to the next one. So with that, I'd like to start off with the 1 to 4 family residential contract, and that is going to be a TREC contract form number 20-12. That's 20-12. And so there were a few changes on this. Just to let you know, the main change was just positioning in the first. The land, improvement, and accessories are collectively referred to as the property was moved from the bottom of D up to the top of paragraph 2. Something else that you'll notice is they have removed and satellite dish system and equipment from all of the contracts. The reason being is because some satellite dishes are actually rentals, and they take them with and the equipment as well. So they've removed that from permanent improvements or permanent accessories. The other change was with the financing, paragraph 4. If you'll notice, we have not for use with residential mortgage financing, and we are going to talk about the reverse mortgage financing addendums at the end of the presentation. The main change on paragraph 6 was number 8. Now, I'm going to preface it by saying I am not a title person. So for clarity, I'm going to ask you to speak to your title affiliate. But just to kind of give you an overview, as you know, typically with the title policy, one of the exceptions is the discrepancy, conflict, shortages in areas or boundary line encroachments or protrusions or overlapping improvements. Typically, those have been deleted from the title policy, but you can purchase additional insurance to go ahead and cover that. Now, what they're saying here is it will not be amended or deleted from the title policy, which basically says we are going to use it as an exception, and it's not going to be amended. It will be not covered, or it will be amended, and that basically says that we do want the coverage, the extra coverage. Now, there are 2 types of coverage as I understand it. There is a coverage in the boundary, but there is also a coverage called a T19 or .1. And this is something that you guys need to talk to your title company with. Get them to explain that, because this could be a benefit for your buyer. Now, it will be paid for either by the buyer or the seller. It's negotiable. The cost is anywhere from 5 to 10% of the actual title policy amount. So if the title policy was $1,000, it would be $100 extra for that extra coverage. So again, I'm not a title person. Without going into a lot of detail about it, I would just refer you to talk to your title company and get them to explain that. But that was a major change. Now, something else that changed with the title company is, as you know, with the commitment, you have to deliver that within 20 days. And now they are changing the exception time for delivery will automatically be extended up to 15 days or 3 days before closing, whichever date is earlier. So that was a change that they put in there as well. The next change is going to be in the notices. We had a new notice. If you will look at page 4, paragraph number 9, propane gas service area. So if the property is located in a propane gas service area, which means there is a retailer that requires that you buy propane gas from them, then it will also be written into the notices down at the county. So there will be not only a disclosure, which we're going to see at the end of the presentation, but there's also going to be a requirement that they actually file that of record with the county. Now, your title company can get that information for you as well, but just to let you know, this is something that is new. And then, of course, paragraph 7. We all love paragraph 7, right? So they have changed D to say the words as is. Now, for those crazy people like myself who do short sales and also work with banks, this as is verbiage is going to make our lives a lot easier. But just to let you know, in paragraph D it says, as is means the present condition of the property with any and all defects and without warranty, except for the warranties of title and the warranties in the contract. The buyer's agreement to accept the property as is under paragraph 71 or 2 does not preclude the buyer from inspecting the property under paragraph 7A, from negotiating repairs or treatments in a subsequent amendment, or from terminating this contract during the option period, if any. So understand, we still have the option to go ahead and get the property inspected, negotiate repairs. That has not changed at all. The only change is just the verbiage. So again, in paragraph 1, you have as is. Paragraph 2 is still as is, provided the seller at seller's expense do the following specific treatments and repairs. And again, they caution us, please do not put things like subject to inspections. That is not a specific repair or treatment. So do not put that. And then they just marked this bottom out and moved it to paragraph 7D at the beginning. Now, originally, they were going to put the leases in the notice area. Time will tell whether that was the right place or in possession where they actually changed and put it. Time will tell which area is better. However, I just wanted you to know they were thinking about putting leases there. We are going to talk about that in the possession paragraph. So one thing too, getting on the subject of repairs, was who has to do the repair once the property has been inspected. So the key is it needs to be performed by a person licensed. Now, as we all know, there are some persons that do repairs. They do them as a business, but they're not licensed. A good example is a roofer. They don't have to be licensed. So TREC went back, Broker Lawyer Committee went back and said, okay, if no license is required, then they are commercially engaged in the trade of providing those repairs or treatments. It's all good. The key is just be careful that you're not letting Uncle Bob work on the plumbing. Okay, that's kind of the issue. They just want to make sure that it's someone that is licensed, that does the repair and knows what they're doing. And again, something that changed was if the repairs, lender required repairs, are not done, or completion of repairs are not done, then they will extend the close date up to 5 days versus the 15 that it used to be. So that time was shored up a bit. So remember that. And then at closing, they did change this to a paragraph B at closing. It says the property, if it's subject to a residential lease, then the seller shall transfer security deposits, if any, to the buyer. In such an event, the buyer will deliver to the tenant a signed statement acknowledging the buyer has received the security deposit and is responsible for the return of it. And it will specify the exact dollar amount of the security deposit. Now, because sometimes we buy properties that have leases in place, we need to get copies of those leases and we need to know what the rents are, how things are going, everything about it. So they did put that in the possession paragraph. So they changed this to a buyer's possession, or B, if it is under a lease. So it lets you know, and listing agents, this is really important for you. After the effective date, the seller may not execute any lease, and that is including but not limited to mineral leases, or convey any interest in the property without the buyer's written consent. And if the property is subject to any lease to which the seller is a party, the seller shall deliver to the buyer copies of the leases and any move-in condition forms signed by the tenant within 7 days after the effective date of the contract. So listing agents, it's really important that we get that information to them quickly. The only other change that we had was the mediation paragraph. Now, as you know, we had either will or will not. And I know that there are some clients that do not mediate, they arbitrate only, but you need to let them know that the Broker Lawyer Committee has decided mediation is it. You will mediate regardless. Of course, it does not preclude you from seeking equitable relief or going to court, but mediation will happen first. So it's not a will or will not, it is. It just is. The other change that we had was, of course, because we have that addendum for property in a propane gas system service area, we've got that added to the notices in paragraph 22, the attachments. And this will make everyone extremely happy. I am just dancing right now. I'm so excited about this one. Paragraph 23, the option paragraph. We have 3 days, folks. 3 days to deliver the option money. I am so excited because if I execute a contract on Friday night, that means I have until Monday. I don't have to run all over town over the weekend to deliver that option. So I know I hear a lot of people clapping in the background, so I know that's a great thing. Now, paragraph 24. The only addition they add is they just put before signing. And of course, you know, Trello requires that we let them know they have the right to consult an attorney. So consequently, they just said before signing, if you want to consult an attorney, you can. It doesn't say if you do not understand, you know, you need to consult an attorney. They mark that off. And then last but not least, the final page is print your names. You do not have to sign. So over here you have the name of the associate's name. Again, name of the associate supervisor on line 1, the associate's name on line 2. And then something interesting down here, if it's an in-house or intermediary, then down here you have the selling associate's name and also their supervisor. So if you are working with a team, you're going to have your team leader supervisor name as well. So those are the only changes that we had for the 1 to 4 family. Are there any questions? All right, awesome. Moving right along. The next thing that we're going to have is going to be the new home construction contract. It's going to be completed construction. That is a TREC form 24-13, again 24-13. On all of these contracts, you're going to see a lot of the same things we just went over in the 1 to 4. So I'm not going to spend a lot of time with them. Again, the financing, again, not for use with the reverse mortgage. The title policy, again, we have either will not be amended or will be amended for the additional policy coverage. And again, you've got 3 days prior to closing as far as a time for delivery. And then, of course, we have the propane gas service system. Again, that as is verbiage in the property condition. Again, completion of repairs treatments must be licensed or person who commercially engages in that trade. Close date will be extended only up to 5 days. That's up from 15. And on the seller disclosure in the new completed construction, they added the words that either materially and adversely affect the property. So as you know, we don't have to give a seller disclosure on new build properties. However, there are some disclosures that the builder should give. For one thing, flooding, any pending litigation, condemnation, special assessments that would affect the property, environmental hazards that materially and adversely affect the property, dump site, landfill, underground tanks, wetlands, any threatened or endangered species. All those have to be disclosed. Even though we don't have a typical quote-unquote seller disclosure, there are some things that have to be disclosed should they be present. And again, the leases, that move down into the possession. So you have at closing, there'll be no liens as usual. And over here, possession, it just lets you know buyer's possession, and also if there was a lease, this lets you know after the effective date, the seller cannot execute any leases. Then the only other change, of course, was the mediation. They dropped, you will mediate no matter what. And over here, paragraph 22 notices you've got the addendum for propane, and yay, the 3-day option. And then again, the last page, the same. You have print names, don't sign, and then you have the supervisor, the associate's name, supervisor. So any questions about that one? All right. New incomplete, new home contract incomplete, which is a TREC form 23-13. Again, 23-13. You're going to see the same thing, folks. Financing not for use with reverse mortgage financing. Again, we have the deleted in paragraph 7. We have will or will not be amended on the title policy for the extra coverage. We have 3 days before closing. The propane gas system service area. The as-is information. The seller disclosure, again, that and adversely affect the property. And of course we have leases, no leases after the effective date. We will mediate no matter what. The addition of the addendum, the 3-day for option, and again, just the printed names. So any questions on that? All right, y'all are a smart group. All right, unimproved property. This is going to be very close to the same. This is going to be a TREC form 9-11, again 9-11. The financing, you have not for use with the reverse mortgage. Again, the amendment, you either will amend or delete from the title policy or will not. 3 days prior to closing, they deliver that. You have propane gas system. And in the unimproved, the only addition you have that's different with the regular contracts, of course, is the Agricultural Development District. It is either in it or not. And then, of course, property condition, we're still going to have the as-is. And then completion of repairs, again, you have to have a licensed person or someone that's commercially engaged. And they shored the dates up. They only extend it to 5 days. You also have the same verbiage in the seller disclosure because there really isn't anything on raw land to disclose other than any flooding which has had a material adverse effect on the use of the property. So they added that verbiage. Any threatening or litigation or pending litigation, condemnation, or special assessments. Environmental hazards that could materially and adversely affect the property, dump sites, landfills, underground takes or containers, wetlands, or any threatened or endangered species. So you're going to have that on there as well. Again, just changed A and B. At closing, the seller shall execute and deliver general warranty deed, pay taxes. And then over here on possession, again, if there was a lease, whether it be a mineral lease, or if they're leasing it out for cattle, whatever kind of lease they have on the property, that needs to be given to the potential new buyer. And again, after the effective date, the seller may not execute any other leases, that includes mineral leases, or convey any interest to the property without the buyer's written consent. Again, listing agents, remember, you only have 7 days after the effective date to get a copy to the buyer of any leases that the seller has, any type of lease at all. And then again, you're going to have under the notices, you're going to have the addendum for property in a propane gas area. You still have the 3-day option, consult an attorney, and then of course don't sign, you just need to print your name. And that's the only changes for the for the unapproved. Any questions on that?
Lori, we have a couple of questions. It says,
Yes.
why 7 days and on the possession for lease? Isn't that too long in case option period is 5 days?
That's a great question. And so here's what I would counsel. Make your option 7 days so that you can get that. They basically have 7 days. The listing agent and seller have 7 days to get to the buyer's agent and the buyer copies of any leases that are on the property currently. So if you need to back out based on the lease you see, then I would go ahead and give myself a couple of extra days on the option period. I hope that answered your question.
Okay, and there's one more. Are these only on the TREC forms? Are they on the TAR forms?
Yes. Yes. So changes that take place on the TREC form translate to TAR forms. If you have, you can use it in the TAR form, you can use it in the TREC. Understand too that really TREC is a promulgated form, and so most of the TAR forms are voluntary. So if there's a TREC form to use, I would always counsel you to use the TREC form first. But these are going to be similar changes. They're going to translate to the same thing because we do have TAR form numbers for some and TREC form numbers for the other. So yes, they are the same. Okay, this is a great question. What steps should a realtor take to ensure that a contractor is commercially engaged? Okay, that's a really good question. So typically, a lot of times if they're not licensed, they don't really have a license you can check out with the state. So you might want to check with, Angie's List or someone else and check and see what reviews they have. Make sure that they're not just slapping a sign on the truck and coming up and pulling up. Ask people, who do you use? Who do you use? Make sure that this is something that they do as a business, okay? The main thing is you just want people that are doing repairs. You want someone that they can go back to. So if something happened, they don't call you, they call the person that repaired it. So it takes you out of the loop. So that's what I would do, is just make sure that it is something that they do, that they have a business, they have a business number, that kind of thing. This should be available in zip forms before very long. They should be on zip form now because these are mandatory as of June 1, and we are creeping up on June 1 very, 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 very quick. So I have another question. If a longtime handyman has an LLC and does general contracting work, is that okay? Yes, because that is what they do professionally. And really, this seems to be where most of the questions come from. It's like, look, I've got a retired guy, he's a handyman, he can do anything, can I use him? Well, if he does this all the time, and this is kind of his deal, then sure. But if it's just, hey, I got this guy that lives next door, he's a retired journeyman, he's a retired master electrician, I could ask him to do something, but this is not what he does, just understand you're putting yourself and your client at risk. So TREC says, it needs to be somebody that does this all the time. Not somebody that maybe knows how to fix it, but somebody that does it all the time. Does this mean the seller can't make any type of repairs anymore? Great question. I asked legal counsel, what is the deal with this? Because we do have a lot of questions, especially when we teach contract classes. Why can't the buyer and the seller, do the repairs themselves? What's the deal with the seller not doing the repair himself? And legal said there's nothing that says the seller cannot do the repairs themselves. However, the issue is not so much the ability, the issue is the risk. And what I mean by that is maybe your seller is really handy. Maybe your seller can change out GFCI plugs. Maybe your seller can do a little electrical or plumbing. But what if the house burned down a week after the buyers moved in? And then they ask, who did the electrical work on this? And you go, well, the seller did it. Well, is the seller licensed? No. Then that could just open up a big can of risk. So just to cover yourself and cover your seller, and you just need to explain to your seller, look, if you want to do things, let's get it inspected before we get a buyer, because then all bets are off. You can do whatever you want. But once the buyer has had it inspected, according to the contract, the repairs must be done by somebody that is commercially involved or licensed. So I hope that answered your question. All right, we're going to move right along to the next form. Now, those of you who do farm and ranch, I'm going to tell you there's a lot of changes on farm and ranch. I'm not so sure I like them, but that's just my own opinion. But here's what's going on with farm and ranch. Farm and ranch is 2510, again, TREC form 2510. And one thing they did in farm and ranch is they added this up at the very beginning when it talks about the property. It says the land improvements, accessories, and crops, except for the exclusions and reservations, are collectively referred to as the property. Again, they took out the satellite dish and equipment, so that was removed. But here is the biggie. Time will tell whether this is a good move or not. Reservations. Now, as you know, on farm and ranch, reservations have always been a little bit different. It says any reservation for oil, gas, or other minerals, and now they've grouped them all together. Water, timber, or other interest is made in accordance with an attached addendum or special provisions. Yes, folks, you heard it. Special provisions. So they're wanting us to write in special provisions. I don't know what's up with that, but we're going to talk a little bit more about that when we look at the other form. Again, financing is not for use with a reverse mortgage financing, the third-party financing. The title amendment deleted, that is the same. Again, shored up the 3 days before closing. The other change on the farm and ranch is the propane gas system. They did add that. They did add the as is verbiage. Same thing, as is. The leases, they moved to the possession. Completion of repairs, again, we're talking about licensed or commercially engaged. And then the seller disclosures, again, they just added that materially and adversely affect the property. Again, if the property is subject to a residential lease, then it says here, in the event the buyer will deliver to the tenant the statement of who's got the security deposit. And then, of course, the leases are the same. After the effective date, the seller can't execute any lease, and within 7 days, you have to provide those copies. And again, we will mediate regardless. The addendum for, now look here in paragraph 22, the notices. The addendum for reservation of oil, gas, and other minerals has been removed. It has been removed because we are not to use this with a farm and ranch contract. This is the new information that we have coming down the wire. The addition for the gas propane was put on. We still have the 3 days for the option. Again, consult an attorney before signing. And then, of course, you've got just, the same page 9 that you always had. Nothing has changed on that. Now, I'm going to talk a little bit about the reservation changes because I'll talk about that towards the end of the presentation because I'm going to ask you guys to do me a favor. The question I have is, would a private agreement for water well use Is that considered a reservation? That's a good question, and it depends on how you're planning on using it. So if you're selling it to the buyer, however, the seller is going to want to continue using that water well, then yes, that would be considered a reservation. But if you're going to convey it to the buyer, and we know anytime we don't say anything, everything gets conveyed with the property. So if you don't reserve anything, it all goes to the new buyer, regardless. But if you reserve something, then that means you keep it for your own use, and then that is not conveyed to the buyer. So we're going to talk a little bit more about that when I get to the addendum, the mineral addendum. So I'm going to kind of hold a couple of questions at that point. Okay, I've got one more question. The seller uses the neighbor's well for the last 19 years and selling it to a buyer. The contract states the home does not have water unless the neighbor allows use of their well. Wow. Okay, this might be beyond the scope of my answering. However, it would seem to me that if the seller is using the neighbor's well for water, the seller does not own the water. So the seller is in effect, quote unquote, leasing the water from the neighbor. So that would need to be disclosed to the new buyer. That would also need to be an agreement that the new buyer and the neighbor would have to make, that would be included somehow in the contract, and you would probably get an attorney to write that up. So I would say that needs to go to an attorney, because we are not in a position where we can create a document like that. Again, on that, you would need to consult the attorney. The good news is, because of TREC, if you buy property, you can have your own well. So your buyer could possibly go ahead and drill their own well on their own property, provided that it does not hurt or harm anyone around them or living near. So I hope that answered your question, but again, that is most likely a legal question. Okay, the last of the contracts are going to be the residential condominium contract. Residential condominium contract. And that is going to be a TREC contract number 30-11. 30-11. And again, we see the satellite dish and equipment being removed from improvements and accessories. And then we see a change here. They have removed number 3, which talks about either the buyer has received a copy of the documents, the buyer has not received, or the buyer has received the affidavit that the seller requested the information. That has been removed. So either the buyer has received, or the buyer will get within so many days a copy of the documents. And then again, financing, we have not for use with the reverse mortgage. And understand, when we say that, we're talking about the third-party financing addendum is not for use with the reverse mortgage. There is another addendum to be used with that. Again, they give you 3 days before closing to get the title commitment if you don't get it within that 20 days. The propane gas system, again, we have that attached should there be a propane gas system. The as-is verbiage is right there in paragraph 7. Again, the completion of repairs, licensed or commercially engaged. Close date can be extended up to 5 days, not 15 like it was before, up to 5 days. And then again, if it's subject to residential lease, we have the verbiage that, you know, the buyer will let them know about the deposit. Again, over in possession, if there are leases, remember listing agents within 7 days, the buyer has to get a copy of the lease and move-in form signed by the tenant. Again, we will mediate no matter what. So for agreement of the parties, we have the addendum for propane, 3-day option. Again, before signing, you can consult an attorney, and then print your name, do not sign. And that's really all for the condo. Any questions about that one? All right. Now, I added the third-party financing addendum because I'm sure most of you know it has changed, but just in case you haven't, I just want to, renew this with you. This will be a good review. Again, this was for use in February 2014. If you'll notice up here, it says not for use with reverse mortgage financing. There is another form, and we're going to look at that form before the presentation is over. Again, understand that this is for the buyer credit worthiness. This allows the buyer to be credit worthy. And the additions that they made to this, everything the same, except they have added the USDA guaranteed financing. So now if you buy USDA, you will be able to use this form to secure your buyer an option, and it will give all the information just like it does for the FHA, VA, and conventional. Now here is the propane gas service system. This is the information, and basically it is a notice. It says you are about to purchase in an area which is authorized by law to provide propane gas service. Because of that, there may be a special cost or charges. You may be required to pay before you can receive gas service. You might be required to construct lines or other facilities necessary to provide that service to your property. And you need to contact the distribution system retailer to determine the cost. So it says here, buyer hereby acknowledges receipt of this notice at or before execution of a binding contract for the purchase of the above referenced real property, or at the closing of real property. And it says here, a copy of the recorded notice is attached. Now, where do you get that? Well, the seller can obtain that from the county clerk's office. So this is something, as I said, that is filed of record. It is attached to the property. If the title company pulls up the information, this should pull up right with it. And this is new. This is new. Okay, the other change was to the subdivision information, including resale certificate for property subject to a mandatory membership in a property owners association. This went live as of February of 2014. There was a very small change on paragraph H. I had to look at this 2 or 3 times to figure out what did they change. So this is it. They added in the association in which the association is a party. So they're talking about lawsuits or litigation, and this is added in which the association is a party. So that is the only change that was made on that. Reverse mortgage. Now, I'm going to just say this about reverse mortgage. You actually have a webinar that MetroTex has on their live webinar site that you can actually watch, and it will give you some questions that will answer anything that you want to know about reverse mortgage. Also, contact your lender. Find out from your lender what all this entails. As I say, I'm always going to give a commercial. I am not I am not a mortgage person, but here's what I do know about this form. It went out in April of 2014. It is for voluntary use through TREC, and it is TREC form number OP-N. Again, that's OP-N. And on this, it just says that this is used when a buyer who is 62 years or older wants to buy a property that is going to be their primary residence. So yes, this is something they can purchase new. It is their primary residence. They must move in within 60 days. And they have to be credit worthy in order to get this. Again, you're going to put the principal amount, whether it is a fixed rate or variable rate. You're going to have an interest rate not to exceed. This is looking very much like the third-party financing addendum. You have adjusted origination charges, not to exceed a percentage of the loan. It will or will not be FHA insured. Again, approval is approved when the buyer and the property have obtained approval. The approval for the buyer is going to be within so many days. just like the third-party financing. If for any reason they cannot get the financing, then they can terminate the contract and get their earnest money back. The property approval, remember, listing agents, it goes all the way to closing. So if it doesn't meet the lender's requirements, underwriting, appraisal, insurability, etc., then it can terminate and the money will be refunded to the buyer. Again, with FHA financing, it lets you know if the house doesn't appraise, they don't have to move forward. And that is all there is to that form.
There is a question, Lori.
Okay.
What does voluntary use mean? Is it not required?
That's correct. It is voluntary use. So this is not a mandated form. This is for voluntary use. It means that if you want to use this form, you can. If you don't want to use the form, you do not have to. Understand that if you're using a regular 1-to-4 family contract, for example, and let's say that you have someone that is buying on a reverse mortgage, it would be nice to have this to protect your client, because this takes the place of a third-party financing addendum, which gives your buyer an out. If you don't use this form, then you would not check anything in the third-party financing part of paragraph 4 on page 1 of the contract. So this just gives you an opportunity to protect your client, and that's what I say all the time, protect your client. So it is voluntary. You do not have to use it. Okay, we only have 2 more forms and then we are done. All right, the addendum for property subject to mandatory membership. Let me explain these next 2 forms, and here's what I'm going to ask you to do for me. These are still under consideration. You can go to texasrealestate.com, click on the For Realtors tab at the top. There is a tab that says Form Changes, and there's another tab that says Forms under Revision. Click that tab and it will show you what I'm getting ready to show you here, and it allows for you to weigh in and give your opinion. Please do so. On the right hand side there is a link to click, and you can tell them what you think about the changes on these forms. The mineral form I am really concerned with, and I'm going to share that with you here in just a minute. But on the HOA, really the only change was this. They just added and E. So basically everything is up to the buyer to pay to get it transferred, except for if for any reason in A you had the seller is going to provide that, or in D, the deposits and reserves, it says the buyer will pay for that, and or E, the seller authorizes the association to release information to the buyer or the title company. That was the only change on that particular one. Now here's the biggie. Again, these are up for grabs, so we don't have these as this is the way it's going to be. Again, they are saying that they do not want us to use this form with the TREC Farm and Ranch contract form, which basically means that if you're going to reserve anything on a contract that is a farm and ranch, timber, air, water, mineral, whatever, that you are going to need to get an attorney to draw up a form. I think that's going to cause undue problem for the client, but that's just my opinion. But that's the way they're going to make it, is you're going to have to either create a form through an attorney and attach it, or you're going to have to write something, God forbid, in special provisions. And I thought we were getting away from that. But it looks like that's the way it's going to go. So here are the new changes that they are considering currently. So again, they marked out for use only if seller is reserving all or a portion. They are now stating we can only reserve a particular amount, either all, a half, or 1/4 of the seller's interest in the oil, gas, and other minerals in and under the property that may be produced from it. If the seller does not own all of the oil and gas and other minerals, the seller reserves only this fraction of their interest. Okay? They have knocked out all the other verbiage about they either reserve all, they reserve undivided. It is, production of drilling rights. All that has been removed. And then they're going to say either the seller does or does not retain rights of ingress and egress and the right to use the surface for purposes of mining, drilling, exploring, operating, developing, or removing the oil, gas, and other minerals. So basically, the surface rights is what it's talking about, and it just kind of goes in detail. And then also, if the seller does not reserve all of the seller's interest, then the seller shall, on or before the close date, provide the buyer the contact information of any existing lessee known to the seller. Again, consult an attorney before signing and read this form carefully. So basically, if you just have, like where I work, everybody gets a sign-on bonus for a promise of a possibility of having minerals and royalties paid, then you're supposed to give that to them. Even though we don't really have a lease or gas, that would be a disclosure. So I think it's just going to open up a big can of, worms that maybe we are not ready to get involved in. That's my only opinion, and that's just my opinion. But I do want you guys to look at this, weigh in with TAR, let them know what you're thinking, weigh in with TREC. You can also go to, you can also send an email to general.counsel@trec.texas.gov. Again, that's general.counsel, COUNSEL, at trec.texas.gov. Let them know your thoughts, because you guys work in these forms all the time. Let them know what you think, if this is a good thing, if it's a bad thing. They need to know. They want to know. And these last two forms, just to let you know, they are still out there trying to decide if this would be a good move. So weigh in, let them know, and that's all I have for you. If you have any questions, now's the time to ask.
Lori, is there a deadline for reviewing these last two forms on texasrealestate.com?
I'm looking at my notes. I don't see a deadline. I know that they were revised at the April 28th meeting. They'll be posted for a public comment period. Now, I don't think the comment period is going to be for too long, so I would get on there today and comment. We'll probably go through maybe the end of this month. And then at that point, they'll decide whether they want to go ahead and make this mandatory or not. So now's the time. I see a lot of questions. Is it possible to get a copy of this presentation? Yes, absolutely. So if you want a copy, email Karen or Amy and let us know at Professional Development. We are happy to get you a copy. All right. So just to let you know, too, there is a new form that is coming up, and it probably won't be out until August, but I do want to kind of tell you. There is a new form called a Mutual Termination of Contract and Release of Earnest Money form. It looks like it is going to be adopted maybe late August. But the neat thing about this one, this is a great form. It is actually a two-fold form, and it will take the place of the release of earnest money in the for the title company. The good news is that when you make a contract, you have what they call equitable title, which means the buyer actually has a interest in that property. So should they decide they don't want to move forward and they terminate the contract, up until this point, unless the earnest money was released, they really still had a little bit of equitable title to the property, which meant basically it's going to be hard for them to sell it to someone else, because if they come back and decide, oh, I want it, then there could be an issue. So this form will actually negate the equitable title and then deal with the earnest money at a later date. Or on the form, you can deal with the earnest money then. But I think this is a great form that they've come up with, and so look for that in August. We'll probably see more on that. So the question I have is, are these the actual changes on the mineral addendum, or is this just what they are thinking they want to change? Currently, it is just what they're thinking they want to change. Now, as we all know, a lot of times when they do these and they don't hear from anyone, then guess what? It automatically becomes the change. So I would encourage you all to weigh in on this, give your opinions. If you think this is going to be great for your business, wonderful, let them know. If you think this might be a problem for your clients, let them know. Let them know what you think, because trust me, when you weigh in, they listen. Another question I have, is it common to waive the right to surface use? Is that because buyers want to prevent adverse use during drilling? Yes, that is correct. It's interesting because what I see with this particular mineral rights agreement is, as you know, we most of us live near the Barnett Shale. The majority of drilling is off-site, but it's a lateral drill. And so consequently, they don't need to be on your property. Unlike oil, where you have to be on the property, it's a straight down drill. And if there were exploration or drilling of that, then obviously surface rights removed. That means nobody comes on your property to drill. Now, with that being said, the new T19 or Doc 1 insurance will cover damage done because of any drilling. So I would encourage you to talk to your title company about that additional coverage, because not only does that protect you now, it protects you through the life that you own the property. And some of those protections have to do with issues with drilling, etc. So again, talk to your title company. Again, that insurance is the T19 or Dot 1. So again, T19, T as in Tom, 19 or Dot 1. So have a talk with your title people and find out what that entails. What happens if you use the old 1 to 4 family residential contract, but property doesn't close until after June? You're fine. These are not mandatory until June 1. So once, that was probably executed prior to June 1, so you're okay. But after June 1, make sure that you and your peers are using the new contracts. If you don't, and something happens, you could be fined for using an old contract. So just to let you know. With regard to repairs, what remedy would a buyer have should repairs be agreed upon? An amendment is executed, and prior to close, the buyer discovers that the seller made repairs on their own. Good question. Again, I think that's a legal question. I'm going to defer to get legal counsel on that. You can always refer back to the contract, but remember, we can't practice law without a license, but we can, read the contract and go, according to the terms of the contract, this is what it says. Now, depending on what your amendment said, if your amendment said by a licensed or commercially engaged person, then obviously that was not done properly and you're going to have to seek legal counsel. So I wish I had a better answer, but that's my answer. Okay, so I see there's no more questions. We are at the end. Thank you so much for coming, and I think Karen and Amy have some more information for you, and I hope this was informative and fun. Thanks for having me.